page and some following sections, you may very well see and should see some paragraphs that give powers to your agent to deal with your trust, to place assets in the trust, to deal with the trustee, to deal with rights to principal. There may be 4, 5, 6 different powers that deal with the trust. So you'll be looking at those specifically. Do browse through there. Based upon the meetings you've already had with us, those powers should make sense to you. But otherwise, feel free to call and talk to us about what are you talking about in those powers. The next section, again, expanding the powers, you'll see deals with gifting. And there's really 2 types of gifting that we have considered and that you may have instructed us to put in. You may see a power that allows your agent to make gifts as per the federal estate tax gift regulations. It's important for you to realize that Illinois does not have a gift tax, so we're not dealing with Illinois in these powers, we're dealing with the federal government. And we may be dealing with the annual exclusion gifts, which right now is $14,000, and from time to time the government changes that, so we'll always keep you advised if you're talking about doing that and or allowing your agent to do that. 2 reasons you may want to give your agent that power to gift. Number 1, you're doing gifts. You're gifting every year to your children or to your grandchildren or nieces or nephews, to any group of people, and you say, even if I'm sick and I'm laying in the hospital or I become incompetent, I want these gifts to continue and I want the agent to be able to do that, so we're going to put the power in. The other reason you may be doing gifting is to reduce the value of your estate. You're going to be doing these yearly exclusion gifts to bring the value of the estate down so that you don't owe federal estate tax at the time of your death. Both of those reasons could be in vogue for you, or one or the other. The other type of gifting, we here in the office call it the catastrophic illness gifting. This has come into being as we see more and more people going into the nursing home. And it may be something that you're concerned with, most of us are. You're saying in a catastrophic gifting power, if I am going into the nursing home, agent, I want you to consider that fact. And if it is apparent that I am not going to be coming home from the nursing home, and that the nursing home may start to cause the sale of my assets and getting into my estate for my care, I want you to give those assets away. And we may say, try to follow my estate plan to the best of your ability, and within the law. You cannot automatically qualify someone for public aid anymore. I mean, it's a very time-consuming sort of process. In other words, if I give this pin away and I go in the nursing home the year after I give it away, the value of this pin can still be figured in as being capable of being used for my nursing home care. 5 years has to go by. So your agent would really have to sit down with someone who understands the Medicaid laws before they just start willy-nilly giving things away. And we would hope that they'd follow the estate plan that they've already put into effect. So regular gifting, I just want you to continue gifts that I've been making to people, or I want you to decrease the value of my estate. Catastrophic, make gifts to protect it from the nursing homes. On to the next page. Your agent has the right to delegate duties. In other words, if there's something that the agent doesn't feel comfortable in doing, like investments, you may have a broker that the agent is going to delegate the power to make those investments. Just as you may be counting on a broker, you're saying my agent can do that. Your agent's entitled to reimbursements of money they spend in your behalf, their own money that is that they spend in your behalf, and also reasonable compensation. Now you have the right to say, I'm not going to pay them. I mean, I have my daughter doing this, and I'm not going to pay them. That's the agreement we have. You just strike through number 5 and they do it for free.
Yeah, I'd be hesitant to have you do that. A lot of times when people are making decisions, whether it's under the healthcare power of attorney or the property power of attorney, they're taking significant portions of their life away and dedicating it to that. And it may be that they're taking time off their jobs or incurring additional expense or whatever the case may be. So if you're going to delete that power, really think about what you're asking of your agent to do for you in exchange for no pay. Now in most cases, if it's a family member or a friend, they're not gonna charge to help you do these things. But if the burden is high for them, they may need to consider getting paid, and of course, if you've already said they can't be, they may decide not to assist. So be very careful if you're gonna delete that power.
And if you've really picked someone that you trust, and that you have confidence in to do this, are they gonna take advantage of you?
No, and that's the whole point of you picking that person, is you trust them to make good decisions on your behalf with your money, and they're not gonna overcharge you for this work.
Now, the next clause, and it's usually number 6, spells out when the power of attorney becomes effective. Generally speaking, it becomes effective on the day you sign it. So, yes, the person can act as your agent that day. And it goes on, as I said earlier, until the date of death or until you would otherwise terminate it, because you always have the right to terminate it. The only time that we really do something different than what the statutory power of attorney says is effective when you sign it and until the date of death is for a specific purpose. We do it a lot of times for real estate transactions. In other words, you say, I'm going to appoint this person as my agent to do this specific job, close this real estate transaction for me, and that's the only thing that they do, and when that's over, there's no longer a power of attorney. And you can do that, but typically, when you're doing an estate plan, it's from the date you sign it until the date that you would revoke it or pass away. And we have gone ahead and filled that in for you in number 7. If you go on to item number 8, this is your backup agent or agents. In other words, I said you could have a first agent, a second agent, a third agent, a fourth agent. They serve in that order. In number 8, again, so you're looking at names, addresses, phone numbers. Make sure they're correct. Again, call if you see that there's something different. Like Maury was saying in the healthcare power of attorney, in the notice provisions under the healthcare, if you don't have an agent, the court can appoint someone. Well, in the power of attorney for property and healthcare, Maury and I have both been involved in cases where the person's gone through the power of attorney and appointed an agent, and there's a fight among the children or other beneficiaries of the estate, and the judge is sitting here saying, well, I don't care what the power of attorney says, I'm going to do something different. Well, number 9 under the property power of attorney allows you to say, if I need a guardian of my estate, I appoint the same person that you appointed as agent. You can put in, you can actually say, if the judge is doing that to me, I still want that person to serve, only he's going to be serving as the guardian.
Sure.
We can't guarantee that the judge is going to follow that,
Sure.
but it does give some credence to what you wanted. So it's something that we would definitely recommend that you do. And then as with the healthcare power of attorney, you're going to sign it, but I want to point out number 11. Let's read through that together. The notice to agent is incorporated by reference and included as part of this form. That is not the notice that I reviewed with you just as we began this property power of attorney. If you turn back a couple of pages, it's actually one of the last pages. You're going to see at the top of the page, notice to agent. That notice to agent is something, if you have the opportunity, please let the person you name to be your agent read through that. It's just a page, but they may have questions after they read through that. This is not to you. We've gone over the notice to you. This is the notice that we would like for your agent to look at. And if they have questions and you think that they're very serious questions, bring them to the appointment with you. Have them call us. We'll deal with it. We'll try to put them at ease. So make sure you take a look at that. Then your signature is required. We do need your signature witnessed by 2 witnesses. And then you'll see, following those witness pages, a notary section and a places for, we have oftentimes the agents sign as well if they're available for the appointment. It's not a legal requirement, but if you have someone that's willing to come in for the appointment, we have them sign as well. So with that, we'll conclude this presentation with regard to powers of attorney. Maury, I think you have a few comments?
Yeah, just one other thing. I mentioned in the healthcare power of attorney that it's important to select an agent with proximity to you, someone who's close, that can help you in an emergency situation. I don't think that's as important with the property power of attorney. things these days with money and property can be done by fax, email, phone, and it's not as important and usually not as critical in the middle of the night, for example, that someone has immediate access to money. So don't feel that you have to select someone to deal with the money part of this or the business part of this that's living next to you or near you. You can select someone that's farther away for that job, and that's not as big of a deal.
That's a good point.
So to conclude this discussion, powers of attorney are very important because they are allowing you to pick an agent, someone that can make legal decisions for you. And those decisions, if your agent makes them, are going to be legally binding, just as if you made them. With the healthcare, it's making all of your medical decisions, including reviewing charts and records and reports and end-of-life care, putting you in facilities, that kind of thing. With the property power of attorney, they can make any business or money-related decision that you could make. But for that property power of attorney, it applies to things that are not in trust. So if you're using a trust as a part of your plan, you're going to name a trustee to make those decisions for you. The property power of attorney agent is going to be making decisions as to things that are not in trust. But again, they can make or sign any contracts that you could do and otherwise deal with accounts and things that are in your name. Again, it's important to select agents that you trust, and that's one of the paramount things here, because they have a lot of legal authority over you and your affairs. And they're going to be making critical decisions on your behalf. If you have any questions about the powers of attorney that we haven't answered here, please feel free to ask us about those, either in your appointment or if you think that's going to lead to changes prior to your appointment for signing. Thank you for watching, and we hope you have enjoyed the video and have gotten some good information out of it.
Thank you.